Ще раз добрий вечір. І ще раз перепрошую за невеличку таку
Good
технічну
evening once
затримку
again,
нашої
and sorry
розмови,
for
але я
this
сподіваюся,
technical
попри це
delay in
ми
our talk,
встигнемо з
but I hope
вами
that in
все,
spite
що
of that,
запланували.
we will manage to do everything
Власне,
that we
я рада
actually
вітати
planned
всіх на
for
нашій
today. So I'm
дискусії
happy to
сьогодні.
welcome all of you
Сподіваюсь,
today at
вас
our
інтригуючою
discussion.
назвою
I
«Хто
hope
вони?»
that
Майбутні
the title
обвинувачені
is rather
спецтрибуналу щодо
intriguing.
злочину
Who are they,
агресії
the
проти
future
України,
defendants of the
що
Special Tribunal
організовує
for the
JustTalk
crime of
у
aggression
партнерстві з
against
Міжнародною
Ukraine, organized by
асоціацією юристів.
JustTalk together with the
І,
International Bar
власне,
Association?
цю дискусію вчергове
And
ми маємо можливість
this
чудово проводити в
discussion
просторі
is
провокатора за
another
сприяння
opportunity
координаційного
that we
центру з
have in this
надання правничої
Provocator
допомоги,
Center with
за що ми
the
теж дуже
promotion of the
дякуємо
Coordination
координаційному
Center for
центру.
Legal Aid,
Мене
for
звати
which
Дар'я
fact we are
Свиридова,
very
я
much
партнерка
grateful.
адвокатського
I'm
об'єднання
Daria
«Озонс». І,
Sveridova
власне,
and I'm
сьогодні
the
маю
partner of
честь і
Azon's
радість
law
бути
firm. And here
модераторкою
I'm
цієї
lucky to
розмови,
be the
дискусії
moderator of
на
our
важливу
today's talk and
і
discussion, which is
непросту, як на
dedicated
мене,
to a very
тему.
important and a very difficult topic.
Формат нашої розмови буде
The
традиційний для тих,
format
хто
of
вже не
our
вперше на
discussion is going to
дискусіях
be traditional
JustTalk.
for
Для тих,
those
хто,
who have been
можливо, вперше
attending
я
our
декілька слова
discussions, and
розкажу.
for those who are here for the
Формат
first
дискусії
time, let me
передбачає
just share
виступи
the information
спікерів.
about the
Після
format of
кожного
our
виступу
discussion, which
спікерів
presupposes
в
the
вас буде
speeches of our
можливість
speakers. And
виступити
after
з
every
невеликою
speech,
інтервенцією, з
you will have
коротким
a chance
питанням,
to
яке
make a short
передбачатиме
intervention
коротку
or
відповідь
ask a quick
або
question,
з
which will
короткою
presuppose a
рефлексією.
quick answer,
І
or you
після
may have a
виступів
quick
всіх
reflection.
спікерів,
And after the
власне, ми
speeches
очікуємо
of all
широку
the
вже
presenters,
дискусію
we
з
expect to
розлогими
have a
питаннями, з
longer
розлогими
Q&A
відповідями,
session
з
and
залученням
a
аудиторії
longer
не
session
лише
of comments
офлайн,
with
але і
engagement of the
онлайн.
audience, not only
Наша
from
дискусія сьогодні
offline, but also
транслюється
from
в
online,
Zoom, тож я
because we have the
звертаюся до
broadcast
учасників,
in
які
Zoom.
зараз
So I'm
слухають
also
нас в Zoom.
addressing the
Ви так
participants
само
listening to
можете
us in Zoom. You will
писати ваші
also have a
питання,
chance
рефлексії в
to
чат в Zoom.
ask your
Це все будуть нам
questions or to
передавати.
put
Ми
your
обов'язково
reflections in the
це
chat, because all this
озвучимо.
information will be further to us, and we will definitely try to
Також буде
voice
в
all
нас,
that.
якщо не помиляюсь,
We,
організаторами не
if I'm
можуть
not
направити, буде
mistaken,
запис сьогоднішньої нашої
will have
розмови,
also the
і ви
recording of
зможете
our
ще раз
today's
насолодитися,
talk, and you
порадити
will have
своїм
a chance
колегам,
to
послухати
enjoy it
подкаст,
once again,
який
or you
буде
could
створений по
recommend it
результатах
to your
сьогоднішньої
colleagues,
дискусії.
because there will be the podcast
Власне,
presented as a
зараз я би
result of
хотіла
our
просто
today's discussion. And
представити
now
наших
let
спікерів
me
сьогодні.
introduce our today's
Це,
speakers.
власне, Надія Волкова,
So
директорка
we have Nadia Volkova,
Ukrainian
Director
Legal
of
Advisory
Ukrainian
Group,
Law Advisory Group.
Антон Кореневич,
We
посол
have
з
Anton
особливих доручень
Koronavich,
Міністерства
the
закордонних справ України,
ambassador for special
Марк Еліс, виконавчий директор
assignments
Міжнародної
of the
асоціації
Ministry of
юристів.
Foreign Affairs of
І
Ukraine,
ще ви
Mike
бачите
Ellis,
один
the executive
стілець.
director of the
Він
International
не
Bar
пустий і
Association,
не
and you
онлайн, а
see
до нас, я дуже
one seat
сподіваюся, попри
which is
все і попри
empty, but
коротку
I
в'їзд у Київ,
hope that
долучиться
in
пан
spite
Андрій
of the
Лещенко,
traffic
заступник
jams and the rain
генерального прокурора.
catastrophe, Andriy Lashchenko,
А
Deputy
почати
Prosecutor
нашу
General, is going to
дискусію,
join
власне, я
us
би
and to take this
хотіла
seat.
з
And at the
ще
beginning
одного
of this
учасника, який
discussion,
долучиться до
I
нас
would
онлайн.
ask
Власне,
another
з нами
participant
онлайн
who is going to
сьогодні
join us online.
Джордж Артлі,
This
менеджер
is George
проектної
Artley,
команди
manager of
Міжнародної
the
асоціації
project team of
юристів,
the International Bar
якому би я
Association,
хотіла
to
надати
take
слово
the
для
floor. I would like to give the
відкриття
floor to you,
нашої дискусії
George,
сьогодні.
to launch our today's
George,
discussion.
the
Over
floor
to
is
you, George.
yours.
Thank you very much indeed. I hope you can all hear me and that you've all managed to stay dry. Very honoured yet again to welcome you all and thank you on behalf of the International Bar
Можливість
Association.
відкривати
Even
цю
though you
дискусію
have
від
Mark
імені
Ellis there who
Міжнародної
will be
асоціації
speaking,
юристів,
but I'm
попри те,
only,
що з
so
вами
I just
виконавчий
note
директор
that
нашої
I could have held this
асоціації
until
Марк
the floor
Еліс.
here. Perhaps
Якби я був там, то я
next
би
time.
міг тоді
I'll
притримати йому
keep this brief
парасольку,
though,
але,
given we've got a bit of
мабуть,
time, just
я
to
це
say
зроблю
this is the fifth
наступного
event of
разу.
the
Але,
group.
власне, це вже п'ята подія, щоб не втрачати часу, перейду до
Organised with
суті. Це вже
JustTalk.
п'ята подія, яку
It's
ми
an
організовуємо
immense
спільно із Just
privilege
Talk.
and
І для мене
it's
величезна
an excellent
честь
opportunity for us all to come together to discuss this crucial issue, of
разом з
course,
вами
of the
обговорювати всі ці
Special
важливі
Tribunal,
питання,
which is
які стосуються
something that the
створення
IBA and certainly Mark have
спецтрибуналу.
been working on now
Бо
since at least
це ідея,
September
над якою ми з Марком
2022.
працюємо
I think
вже
when Mark
як
made the
мінімум з
first visit
вересня
to Ukraine
2022 року,
after
коли
the
ми
beginning
здійснили
of the
свій перший
war,
візит до України з
and
моменту
indeed
початку
in May of
повномасштабної війни.
2023,
І,
the
власне,
IBA's council, its parliament,
в травні
voted
2023
unanimously to
року
pass a resolution calling for the
ми
creation of a special criminal tribunal for the crime of aggression against. This year already we've had two events, again at which Mark has been speaking, one in Washington, D.C., in part on the Special Tribunal. This event today in many ways represents another example of those discussion panel style events, but this time obviously in Ukraine itself, which is fantastic. And there's going to be another one in The Hague very soon. So with that, I won't keep you any longer, but just to say thank you again for partnering with us for this event. and very much look forward to hearing the conversation that we have together this evening. Thank you.
Speaker, whom I have already introduced, Andrei Lashchenko, who has finally joined us. And I think that we will start with Anton. Sorry, but probably you will have this pleasure, but also the responsibility to be the first speaker. I wouldn't like us to focus on the framework of the Special Tribunal, on the idea of what was needed to create this Special Tribunal, what the architecture was, what the grounds behind that are, because it seems to me that we have in the audience the people who are well prepared for that, and we have a good discussion paper, so all those who would be willing to get better acquainted with all the issues related to the Special Tribunal could actually read it in the discussion paper. Therefore, my question, or rather all the partners who have covered this path together with us, and they tell me that they cannot really truly believe that we would manage to do this with such a quick result. That is what one advisor from one law firm said. The other one says that this is probably the most important thing that he has done in his professional life ever. And I think that this is a good confirmation of the importance of the discussion that we are launching today. Well, definitely we will not focus on the architecture and the mechanism because everyone may really get acquainted with a high quality paper. Thanks a lot to Mykola Pashkovsky who developed this document. All those documents are in public access. But I need to say that definitely every lawyer and every expert will always be getting an impression that, well, here something must be wrong, because diplomacy is always about a discussion about negotiations, and we should finally reach the results which would meet the national interest of Ukraine, and it should be the one our partners and colleagues and friends will be able to live with. So what you see in the Special Tribunal as for now is, as it seems to me, exactly the symbiosis that, first of all, meets our priority of ensuring responsibility and accountability, and it also corresponds to the interests of our international partners and the international community as a whole. Where we are now? Well, in fact, when we hear this question, the first formula that comes to my mind is that the legal work behind it has been done. We as lawyers may actually give our credit cards and I mean our student cards, and we will get a tick there or a grade because this work has been done. The agreement has been signed, ratified by Ukraine. There is the a charter there, the statute. We still need to develop some information about the steering committee, but this is already a political work because the text of the agreement has been adopted and no amendments can be made. So we as lawyers are done. Now comes the work of the politicians, of the diplomats, to accelerate the launching of this mechanism, of this process. What do I mean? For the agreement on the establishment of the Special Tribunal to become valid, we also need to have adopted and approved by the Committee of the Ministers of Europe, the Management Committee agreement or regulation. The Management Committee is something like the Assembly, which means that all the countries that will be the members within this agreement will be joining in the process of the work of the Management Committee, and they will be coordinating the work of the Special Tribunal. So that is a real assembly. But in large partial agreement is a rather specific story, a specific a tool that they have only in the Council of Europe, and for some countries, it's not an international treaty, and they may just take a decision of the government and decide that they will be fulfilling this document. Some of our partners have already said that it will work for them like this. But in Ukraine, we are bound by our framework legislation. We will have to join this enlarged agreement by voting through the parliament, which is exactly the same as ratification, but the name is different. So the political work will now be for the Committee of Minutes, for the Ministerial Committee of the Council of Europe to adopt this enlarged agreement, which means that the ambassadors of the member states should vote in favor of it, and there should be two-thirds of votes. But before this enlarged partial agreement will be put for the consideration of the Ministerial Committee, it's 35, if I'm not mistaken, member states need to give a certain moral commitment to join this agreement. And now all our diplomatic work lies in the fact of getting this pool of 25 or 30 member states, including the main payers of the member states that are members of the Council of Europe, and then this agreement will be put for the consideration of the Ministerial Committee, and then the Management Committee will launch its work. So this is the most important point toward launching the Special Tribunal. We need to ensure as soon as possible the adoption of the enlarged partial agreement, and that's what we are working on. Ukraine has already informed the Secretariat of the Council of Europe. There has been a note from the Minister of Foreign Affairs saying that Ukraine is ready to be the founding member of this enlarged partial agreement and the Management Committee. And Ukraine has already shown its leadership and has shown that this is our priority as for now. So we need to take diplomatic steps and political steps. And then the issue related to the launching of the Special Tribunal will be solved after we already have this enlarged partial agreement, when we are clear about where the Special Tribunal is going to be located, when there is the so-called skeleton team established, which is the team that will launch the work of the Special Tribunal. So in fact, I think that if there is a sufficient political will coming from our international partners, that could all done be rather quickly. But it's not only us on whom it depends. We cannot full-fledgedly guarantee any timelines or any deadlines or any roadmaps, because it does not depend only on Ukraine. Ukraine has done what it was supposed to do, and now the ball is on the side of our international partners. So, of course, we are still responsible, and we will be coordinating the whole process. Regarding your second question, who are they? Who are these people? I think that I share the position stated in the discussion paper. And we can actually say that it gives us the understanding of why we generally need this tribunal. It's not about lack of trust in the national judiciary or investigative bodies or prosecutorial bodies. We are talking rather about the fact that from the point of view of the logic, the international activity, our foreign policy, if it's not only the state, the victim of the aggressor that can bring to account and investigate the cases related to this aggressor state, this is a positive thing. And we see that this special tribunal is going to be a rather compact body, and our international partners also are of the same opinion. It's a rather small body that will be dealing with the issues of accountability of 20, 30 people, which are the top commanders of the Russian Federation that have been passing decisions, that still keep passing decisions about holding this war of aggression against Ukraine. In addition to all those proceedings that we have in now our national domestic courts in the ICC, so the Special Tribunal will be dealing with this narrow issue, while the national domestic courts of Ukraine will keep going under Article 437, considering and investigating into cases related to a different range of defendants. It seems to me it's really important that this Special Tribunal and its architecture has absorbed the best international practices which are currently valid. This is a sort of symbiosis of the ICC and ad hoc criminal tribunals processes. This is the first precedent ever over 80 years, and nobody has ever been working with the crime of aggression. And that's why we have some specific things things that we need to consider, like the role of victims, the role of witnesses. I'm ready to discuss this issue, but we have already discussed this with our partners. It seems to me that it's really important that the special tribunal will be able to work in absentia. This is one of the key characteristics of this body, and the logic behind that was very simple. If an individual, a representative of the top commandment of the Russian Federation, can be brought to account by the national court, why should the special tribunal not be able to do the same? The logic is clear, and I know that many lawyers do have some questions regarding whether in absentia is a legitimate process or no, but I must assure you that the provisions on it in absentia were written by us together with the lawyers of the European Court of Human Rights, and all the standards of the court, of the European Court, are all there, have all been taken into account. So I think that if we work on top leadership and if we work following the in absentia procedure, this special tribunal will give us the things no other body available in the world can give us. It's not just the order, the arrest order or the arrest warrant, but what we really appreciate. But we will have not just arrest warrants, but we will have verdicts against their top leadership, and it will be not in the name by the court in the name of the Ukraine, but in the name of the special tribunal that has this international jurisdiction, international staff, the body that is an independent subject of international law. I think our special tribunal should work that way, but let me give a disclaimer. We cannot tell who the defendants are going to be, because that is the issue not for the politicians to consider, but for the legal bodies, for the judiciary to consider. But it seems to me that at least all the speakers and the representatives of the core groups came to the consensus that a special tribunal should target the top leadership of the Russian Federation, particularly top military leadership. Thank you, Anton. Maybe you have any quick comments in the room? I definitely have one. Suppose you said that this could be political and military leadership, but only of the Russian Federation, but only of the Russian Federation or not? It seems to me it would also be of interest to discuss this, but maybe later. My next question will be for Mark. So Anton has said that the work of the lawyers is over. Lawyers are done and many international partners have been involved. So Mark, your organization has really done a lot, and you are contributing a lot to supporting Ukraine, aiming to achieve justice based on the consequences of this war. You are supporting us. You're working with the lawyers who are working with the overcoming of the consequences of the war. You personally have a great experience, a huge experience of working with this topic. And I would ask you regarding the criticism that we can sometimes hear even from international partners regarding the newly established mechanism. And the most popular critical statements put to doubt the work of the special tribunal includes the things Anton has mentioned. This is the first tribunal that has been created for the first time for many years for the crime of aggression. Somebody considers this as a powerful tool, but some people think that this is going to be the demonstration of just some selective approach to accountability for the crime of aggression. Anton has mentioned that you worked on in absentia proceedings, but in spite of that, it's also criticized because whether this in absentia procedure will be the one that will contribute to the right consequences. So there are a lot of practical things that are criticized and need to be advocated. So maybe you have something to respond to that criticism, or maybe vice versa. You have some questions that you also need to voice to support this criticism.
It's very good to be back here at Just Talk, which I have such respect for. matter to the creation of the tribunals for Yugoslavia, for Rwanda, and of course the International Criminal Court. None of that would have happened without the role of civil society. And so when the tribunal was formally created, I was a little surprised to start reading criticisms from some of the major international civil society organizations about some aspects of the tribunal. And you've touched upon one that was very clear in their critical remarks, and that had to do with the fact that the tribunal will conduct trials in absentia. And the other one, major one, had to do with the immunity issue, head of state immunity. So because I differ in opinion with the other civil society actors, and because I represent the largest organization of lawyers in the world, I feel that it's important to recognize those criticisms and then try to explain those. So with trials in absentia, which of course here in Ukraine you're familiar with because these trials are being conducted now with domestic war crimes trials, so it's something that is part of the ethos of international tribunal. It is, I think, appropriate to say, is trials in absentia the right thing to include in a new tribunal? This is a fundamental question in international law, and it tries to balance the need to bring justice to the common law system, which is very strict on the use of trials in absentia. Generally, you can't do it. But in civil law systems, there is a greater ability to use trials in absentia on that. And that's really important regarding this tribunal. And what international law says is we will permit trials in absentia if there are certain safeguards. And if you can establish certain safeguards, then that's trials in absentia will be permissible. And those safeguards concern, first of all, effective notification. You have to be diligent in trying to ensure that the suspect, the accused, is aware that he or she is being sought for trial. So that's one you have to do. Two, you have to provide competent legal representation. Even if the individual is not in court, you still have to have competent defense lawyers to represent that individual, or the individual can request somebody to represent him or her. Third, you have to ensure the possibility of a retrial if, in fact, the suspect is apprehended or decides to make him or herself known to the court. So you have to do those three. If you do those three, then you're able to meet those international standards. So the question is, for me, immediately, does the tribunal, the statute of the tribunal, does it give these types of safeguards? And the answer is yes. And you look at the statute, I feel very confident in saying that this tribunal allows trials in absentia to occur and to do so consistent with international standards. So I think that's really quite important. But then we move to the second point, and that is the immunity issue. And that actually relates to the trials in absentia, because as Anton said, the targeted individuals for this tribunal will clearly include the top decision makers, because that's what you're doing. You're trying to identify those that prepare, those that initiate, execute this crime of aggression. And generally that's at the very top echelon, those that have effective control. But what's interesting in this tribunal, the statute, is it does not allow trials in absentia for the top leaders, something called the troika. So that would be the head of government, Ministry of Foreign Affairs, and the president. And those three are protected from a third party nation bringing them into court. And this is part of customary international law. So the statute makes that distinction. But this moves to the entire issue of immunity. And the statute of this, the tribunal statute, special tribunal statute, actually is very interesting, because the statute says we do not recognize this head of state immunity. And the head of state immunity is so long as those, for instance, those three individuals are in office, as long as Vladimir Putin stays president, then this type of tribunal will not be able to set out an arrest warrant or apprehend that individual. And this was Anton would know this better than anyone, this was something that was debated and is quite controversial, because civil society, going back to civil society, feels pretty strongly that this protection should disappear. And it does disappear in front of international courts. So for instance, courts that were created, as I mentioned earlier, the Tribunal for Yugoslavia, for Rwanda, they do not recognize head of state immunity. They don't care if Vladimir Putin is president, sitting head of state. Doesn't matter. They can still pursue that individual. And I think it had to be, I've been involved with it, is can you create a tribunal that could mirror the international element, like the ICC or a tribunal, that could ignore this head of state immunity? That was really critical. I always felt that creating a tribunal within the Council of Europe and then including other countries would be able to give you that international element. Or if the UN General Assembly had suggested the creation of that. And of course, if the UN Security Council created it, then that would also happen, but of course, the reality is that would never happen. And so this is, Anton had alluded to the legal part and the political part. And this then was the political compromise. And I understand it was frustrating for many. I recognize it as necessary. And the political compromise was, particularly with the G7 countries, they were simply not willing to create any type of tribunal that would not recognize head of state immunity. Primarily, I would imagine, because history shows this as far back as the proposed trial for Kaiser Wilhelm II, the United States back then didn't want it, and nor did some other countries. Why? Because they didn't want it coming back to them later on. They were not going to create a precedent where another tribunal could look at them. So that was the compromise. And I'm comfortable with the compromise because it allows still this tribunal to investigate, to establish an indictment against the top military and political leaders. It allows them to do that. It simply, though, says we have to suspend proceedings that would suggest that there would be an arrest warrant out for instance, a sitting head of state, Vladimir Putin. But to me, that's just a timing element. You build up the case, you create this significant investigative trial, and you set out an indictment. That to me is very powerful. And eventually, it will come around to where these individuals are no longer protected by head of state immunity. And therefore, the tribunal has done its job legally, and then politically it will move towards ensuring that they are brought to justice. Compromise, yes, but in my opinion, I believe a necessary one in order to ensure that this tribunal is now moving forward.
Thank you. Якщо зала дозволить, я пропоную вам подумати над тезами і ремарками, залишити їх на загальну дискусію.
To Nadia. Mark has been rightfully saying that this work on the tribunal presupposes some compromises between political and legal decisions. However, the discussions and the critical remarks mentioned by Mark coming from international organizations are important not just for the professional environment, because lawyers do understand what a difficult task it was for the lawyers that were building up the architecture of the special tribunal to do it. But for the victims, those compromises sometimes are not clear, or those difficult legal constructs are not clear for them. You represent the organization that has been working for more than 10 years with the national judiciary, you've been working with the protection of the victims, and I've had a look at the latest rating group survey regarding the attitudes of victims to the proceedings that they go through. So more than 80% of the victims of international crimes, and this is, by the way, confirmed also by your research that you did together with the HIST group. So 80% think that in absentia court proceedings with no engagement of the defendants in the court proceedings will not meet their demand for justice. But at the same time, most of their demands for justice, as people say, are connected to the justice for international crimes, and they lay great hopes on the creation of the international mechanism, which the special tribunal actually is. So the expectations of society and victims from the tribunal are very high. Do you really feel this? Do you feel this pressure? How do you communicate with victims, and who are they? Anton has partly shared some information about them, but it's important not only who the future defendants are, but who the future victims that this tribunal will work with are. And will the special tribunal manage to meet the expectations of the victims of Russian aggression in Ukraine? Good evening to everyone. Thank you for the invitation. Thank you, Daria, for your question, and thanks, Anton and Mark, for your remarks. It seems to me that what you say is really so much important, even from the point of view of my intervention, because I will try to both give the answer to the general question we have in our today's discussion, and I will also try to give the answer to your specific question. It seems to me that you're right. To answer the question, who are they, the future defendants, we cannot but take into account the answer to the question, who are they, the future victims the tribunal will work with? And unfortunately, the statute does not give the answer to this question because, as I understand, this is one of the most difficult questions, and the statute does not give the answer, but this does not yet mean that the answer will not come at one point in time. It seems to me that now there are a lot of questions we don't yet have the answer to, but we will definitely get the answer altogether, because it seems to me that the criticism that we are discussing today regarding the tribunal is important only from the point of view of giving good answers. I mean that we, on the basis of those critical remarks, we need to ask ourselves questions. We know that we have the tribunal, we have the mechanism, and we need to work with this mechanism further on. So we should ask ourselves those critical questions. And the result of the special tribunal, of the establishment of the special tribunal, results from a compromise, as mentioned by Mark and Anton. But we should also have the understanding of the fact what this tribunal will be like for us. Unfortunately, there are some interruptions, the internet connection. So based on the results of the survey that you mentioned, well, really, we have 54 respondents who think that actually everyone, well, all of them are victims. And their expectations from justice, of course, are as follows: that the top leadership of the Russian Federation will be brought to account. That's why we can already take their data and discuss how those victims could be engaged in the whole process. And again, when we had the consultations of the core group, it seems to me the Netherlands were the leaders in one of the groups, and they were taking civil society organizations. They were selecting some of those organizations. That's why they had a talk with us. And I would say that now, none of us has the answer to this question. We further need to elaborate on this to get the answer to the question, because the whole country is affected. The whole country is the victim of the crime of aggression, but the tribunal has limited resources, as we all understand. But still, even in that survey, 86% of respondents claim that the story of everyone should be heard. Can we meet that demand? I don't think so. It's questionable. And I would also like to mention one more thing. It seems to me that since we do have the special tribunal and we need to make it as effective as possible, therefore it's really important to outline our work plan, our home assignment, what we need to do to make it happen. Of course, we need to work with victims. We need to work with decision makers regarding the procedure of the special tribunal's operation and the scope of mandate of the special tribunal. And getting back to what Mark said, the tribunal has those safeguards of the effective trial, but it seems to me that we should also ask this question at the national level, and we all quite often have discussions with law enforcement agencies and with judges, because what does this in absentia procedure mean? What does it stand for? Why has it been created, and why is it criticized? It's one thing when, from the legal and from the technical point of view, we're introducing all safeguards, but on the other hand, what do victims get as a result of that? Do they really think that as a result of in absentia procedures, they will get fair justice? And almost all the surveys conducted by us, and not only by us, show that the answer of victims is negative. They claim that in absentia trial proceedings will not meet their demand. But it seems to me that there is some room for improvement here. Why do victims not get the sense of being satisfied and of getting some justice as a result of in absentia trials? That's because the verdicts are not implemented. If we had any precedents when, as a result of an in absentia trial, there is a verdict which is finally enforced, I think that people would feel like, okay, this is an effective mechanism to deal with statistics, to record some facts. They want to see those defendants anyway. They want to see them made accountable. They want to see them behind the bar. or in the status where they are really accountable, and then when they are punished for what they did physically. I don't know even what words I could further use here. So if we speak about the context of the special tribunal, again, there is no answer to this question. Okay, we will have an in absentia trial, then an in absentia verdict. What comes next? Sorry, again, some technical issues. So these verdicts will never be enforced. I mean, the verdicts of in absentia trials. So, well, this is the question I cannot give the answer myself, and I think no one can give the answer how we could enforce those verdicts. I would be interested in having a discussion dedicated to that. I think that, well, it's not a priority one, but that is an assignment with an asterisk. As far as immunity is concerned, I also understand that when we're watching the work of the government and of the Ministry of Foreign Affairs, this issue of immunity always came as an acute one. But it seems to me that if we have a look back at history, when some heads of states were brought to account, there is no room for hysterics here. We have already understood that because almost all heads of states were brought to account when they were no longer in their office. That is history, that is life, and we can see many examples like this throughout our history, and nothing new and nothing that critical in that. The main thing for us is not to lose some faith in that and some hope. Those us and our international partners should keep this inspiration of bringing those people to account, no matter whether it's going to happen as a result of the work of the Special Tribunal or the ICC. It's going to be a long and tedious and painful procedure, but we need to be ready for that, and one day that will happen. And it seems to me that if we have a look at that situation from the point of view of the fact that Special Tribunal is just another occasion, in addition to ICC, to bring real perpetrators to account for one of the worst crimes that has ever existed in the history of mankind. And if we treat it like this is okay. This is very good. But here I'm trying to voice a precaution. We need to keep this inspiration, desire, and enthusiasm. It should always be our priority to do it, and it's just a matter of time when this will happen, the matter of time and the matter of consistency of our efforts. The only thing I'm going to mention, because I know that we are rather pressed for time, is one statement that you could probably think over, and maybe Andrei would also comment on this. This is Article 17 of the statute that speaks about double bringing to account. I mean that if national and domestic courts already brought a person to account, then the special tribunal will not be considering cases like this. And as mentioned by Anton, the special tribunal will deal with the cases of about 20, 30 people that belong to the top military and political leadership of the Russian Federation. And we can already know what people we're talking about. And since Ukraine is actively investigating into a lot of cases under Article 110, 437, therefore we have to understand for ourselves whether we want to try those people at the national level or whether we should leave those cases for the special tribunal when it's launched. It seems to me it's a really tricky question. I don't know the answer to it. Shall we investigate into those cases now, or shall we leave it for the special tribunal? It's like a lottery game. if we could be sure that on that specific day, at that specific time, the special tribunal will launch its operation, if we had this specific date at hand, then we could do the planning in a better way. But since now it's rather vague, the state needs to get clear about the fact whether we're going to persecute those people through the system of national domestic courts, or shall we wait until the special tribunal starts its operation? We already can see some suspicions regarding some of those people under Article 110, and this article actually fits well into Article 17 of the statute, because this is the article that speaks not just on the corpus delicti, but about the specific violation of the territorial integrity, which is the crime of aggression under Article 2 of the statute. So for me, this is a strategic question, and I will really be grateful if Andrei also comments upon this. Thank you, Nadia. Colleagues, any remarks from the room? I think that everybody understands that we are pressed for time, and you're leaving your comments and questions for the Q&A session. So, Andrei, actually, Nadia has already asked you a question, but let me mention that I'm really sure that we will keep and we will have enough inspiration and enthusiasm, no matter when it happens, to bring the perpetrators to account. But you know, one day the national system of the judiciary had enough inspiration to bring to account even rank-and-file Russian soldiers under Article 437. The strategy has changed. Yes, this is a relevant question, I know, for the judiciary. Definitely, that presupposes quite a lot of work on the part of the Office of the Prosecutor General. We understand that the priorities now are a little bit different. The strategic approach to working with this type of crimes is different. But I think that you are already in the process of transformation in some respects because of the establishment of the special tribunal. So my first question to you is whether the special tribunal will somehow affect your work. And the second question will be the one asked by Nadia. What do we do if you already have some investigations under Article 437 or 110, and these are the same people that could be in the cases of whom could be investigated within the special tribunal. So what do we do? Well, thank you for giving the floor to me. I will try to explain our logic, strategy, and even the tactics in the investigation into such crimes. Let me give some comments regarding the previous speeches. I think that the issue of having in absentia trial proceedings is quite new for us. I don't mean that we are always not making any transformations. It's not true. When we have a look at the first tribunals, even the Nuremberg one, it seems to me that there was a precedent when one of the criminals was persecuted following in absentia proceedings. The next tribunals didn't have the in absentia. Then there were some tribunals that changed their rules and introduced this in absentia. That's why we can see that the international law system is developing. It's in the process of evolving, the same as our national system, because we're trying to adjust to the reality and to the needs of the world, to the needs of the key players in the international arena, to the civil society. So for me personally, an in absentia procedure is a promising one, because it's not about recording something, it's not about collecting some evidence base. That's about the establishment of the fact. And when you have the decision of the court which establishes the fact that this or that person has something to do with the with a specific crime, and all the more that this person, this perpetrator, is the agent of a certain state, then there could be legal consequences. Anton said that the work of lawyers is over. Well, again, my personal point of view is that consciously or subconsciously, the Ministry of Foreign Affairs keeps working in this direction. We can see that some security agreements are concluded with member states or with other countries, and in all those security agreements, there is the item about responsibility and accountability, which means that other countries undertake the commitment to support the striving of Ukraine towards bringing the perpetrators committing international crimes to account. This is one more step towards having better arguments in the international arena while having a dialogue with our partners, which we need to show that you have undertaken the commitment. So please let's try to find the mechanism to make it happen, to bring those perpetrators to account. So the work is going on, it's not all over. And regarding the first question, who are they, the future defendants of the Special Tribunal? Well, it has been mentioned a couple of times today that this is the top military and political leadership of the aggressor state, but the international humanitarian law and the crime of aggression by its nature presuppose that the officer of a tactical level may one day become the subject of the crime of aggression even under international law. How do we understand this? We understand this that the person who at the lowest level was the commander of the troops that were engaged in the crime of aggression is already the one that influences the decisions made in the state, because it depends on this person whether the aggression goes on or whether it's stopped. For example, we know that Russia says that there is no war, there is just a special military operation, and then Russia appoints a commander of the troops engaged in the special operation. This is the officer of the operational and tactical level, but he was in charge of all the units and their operation. And these were the units committing this crime of aggression. That's why we're talking not just about the Ministry of Defense and the head of the defense forces or the head of one of the military circuits, because let's say the head of some special type of troops who was effectively controlling the policy of the state is also the one we should focus our attention on. Well, in general, why do we need an in absentia trial, and how could it further be used? How could it be used by the victims if they are a bit dissatisfied? I understand why they are dissatisfied, because we have a verdict, we have a sentence, but it's not enforced, and the person is physically not punished for the crime. The nature of the crime of aggression shows us that, well, since the definition changed a couple of times, and Anton could probably confirm this, the definition of the crime of aggression was one of the most controversial issues for the core group that dealt with writing the statute and establishment of the special tribunal, because aggression in the modern sense is applying power by one state to the other state in violation of the UN Charter. And if we try to prove the contribution of a specific person who is representative of the aggressor state to the launching of the war by this state, then we partly confirm the fact that our state is a victim. On the one hand, like we have one state that is a victim, and the other state that violated the UN Charter is the aggressor state. But then there arises a question regarding reparations caused to victims, and the Special Tribunal for the crime of aggression against Ukraine is not the only international mechanism that enables us to reimburse the losses, to pay repatriations, and we have the register of damages functioning in The Hague, and its task is to collect the information about the physical entities, legal entities that have been affected by the crime of aggression, to assess the level of damages, and then to ensure reparations of those damages. And I'm 100% sure that while considering those issues, the decision of the special tribunal, even as a result of in absentia trials, will be taken into account to prove that there is an international conflict and the Ukrainian state is the victim, while the Russian Federation is the aggressor state. So even from that point of view, availability of the decision of the Special Tribunal is more than a success story. What regards the question about the division of our criminal proceedings, so in this situation, I think that the investigative officer and the prosecutor are the least protected elements, and it's rather difficult to imagine a situation when the investigator and the prosecutor in a case based on the fact of the war of aggression of the Russian Federation against Ukraine do understand that on the one hand they have the criminal code and the code of criminal procedure that they have to take into account. Technical issues, sorry with the sound again. And we may have a different decision of courts of different levels and instances that make it binding for the investigators and prosecutors to introduce the facts that they are investigating into some common database, into the register. The prosecutor, rather the investigative officer, is supposed to establish the evidence and to bring a person to account. But in our code, we don't have any safeguards, and it's not said that the investigator is allowed not to bring a person to account if he has really collected the evidence base, because we all understand that this perpetrator may potentially become the defendant for the special tribunal, and these people will be assessed for the crime of aggression. We understand that suppose I, as the head of the prosecutor's prosecutorial body, cannot tell an investigator or the prosecutor that, in a year's time or in 2 years' time, probably we will have a special trial, and your today's decision about bringing this or that person to account may actually prevent the special tribunal from considering this case. Well, this is pure theory, but I wanted to mention this. That's why I claim that the investigator and the prosecutor are not protected in this situation. We understand that we have to act in the interest of our state, and we understand that the decision of the court of Ukraine differs from the decision of the Special Tribunal, which is an international body. Its decision is going to be much more important because the decision of Ukraine will be enforced only in the territory of Ukraine. But if we have the verdict from the Special Tribunal, then if a number of member states also ratify this statute and undertake the commitments, though it will be possible to make a search and to announce a person missing, and even it will be possible even to engage Interpol for that. So we are working towards that, and we just want to have a court, a tribunal, the decision of which will be of a higher level than that of our domestic courts. And we have the decision of the Supreme Court of the Grand Chamber regarding the crime of aggression, which reduces the lowest threshold in terms of the requirements of the leadership segment among perpetrators. That's why we have quite a lot of work to do. We are collecting the evidence for national courts regarding the people who were partially controlling the military or political activity of the aggressor state. That is something that we are doing based on the decision of the Supreme Court. So that is quite a lot of work to be done. And well, everybody understands what our priority should be, and everybody, I think, understands why at the moment we should focus just on the narrow circle, narrow range of people. And sorry, I forgot your second question. Well, actually, I've already given the answer to both questions, because I also wanted you to speak about the fate of those cases and trials. Well, that's an interesting question. In the statute, we have a norm saying, a provision saying that Ukraine can actually submit proceedings and evidence to a special tribunal And it seems to me it can also give the information to the special tribunal. But if you don't collect the evidence, you will never be able to transfer the evidence. If we don't investigate into the case, we will never be able to transfer the investigation process. The question is only about announcing a suspicion. I support the idea that we should start collecting the evidence base already now, because we all understand that the beginning of the operation of the special tribunal will not come tomorrow or in 2 days. Some procedures still need to be ensured. We need to work with our international partners, but sooner or later, the decision to launch the work of the special tribunal will be there. And I personally think that the task of all our investigative officers and prosecutors working in this direction is to be ready whenever the special tribunal's operation is launched, and then the moment it starts working, we will transfer either the evidence base or the investigative proceedings to the special tribunal, and in that way we will not have any time lost. Otherwise, we may just stay idle and be investigating into war crimes, of which we have many. No, I think that we should start investigating into those crimes of aggression. The evidencing process in the domestic process and in the international process are different. So we need to understand what evidence will be accepted by the special tribunal, unlike domestic courts, because not all of our sources of evidencing will be accepted by the International Tribunal. The international tribunals have a little bit wider perspective. Suppose intelligence data could be treated as evidence, and the reports of civil society organizations could also be treated by the evidence in some cases. And sometimes witnesses, experts are called to court, and he says that I have worked on 99,000 pieces of information on crimes of aggression or war crimes, and I can really state that there is also an element of the crimes against humanity in them. Because, we are now also having a problem with the investigation into the crimes of humanity because of our law. And because of our legislative requirements regarding evidence and acceptance of evidence in court. Yes, but crimes against humanity have already been the subject of our discussion, so I'm encouraging you to watch this Just Talk discussion, because this is another important issue. Thank you, Andrei, and now let me open the space for questions, and I'm urging our offline participants and our Zoom participants to ask questions or to give their remarks. So, dear participants, in case you have some questions, please raise your hands, and I will be happy to give the floor to you. And in the meantime, Andrei, you have said that it's not enough to understand who we want to see in the special tribunal. Before we get to the special tribunal, we need to collect some evidence. And this is an important aspect in the context of the operation of the special tribunal, in particular when we're talking about victims and witnesses, which most often are the key sources of evidence in the international tribunals and international court trials. Correct me if I'm wrong, but it seems to me that you've been one of the participants, and now you're coordinating on behalf of Ukraine the work of the International Center for Prosecution for the Crime of Aggression, which is already working quite a lot in this direction. So maybe you could share some information with us regarding how this work is being done and how it could help the special tribunal for us to really be able to effectively bring defendants to and perpetrators to account. ICDA, which is the International Center of Prosecution for the Crime of Aggression, has been functioning for several years on the base of Eurojust, which hosts the participants of the center for them to be able to coordinate the results of activity and discuss the results. But the Eurojust has also got a strategic communication rule. And the first rule of Eurojust is not to speak about Eurojust. I mean that this communication strategy limits me. I cannot really go into details. But I can share some general information. So in 2022, based on the initiative of the Office of the Prosecutor General, the Joint Investigative Team was established to collect the evidence in war crimes and to investigate into war crimes. It worked for about a year, collected quite a lot of information, and we informed our foreign colleagues that physically we are not able to get the evidence from the people who have left Ukraine because of the hostilities. These are our refugees staying in Europe. And first, we asked them to have interviews with those people and to share the information about specific war crimes of which they were witnesses or victims with us. This mechanism worked for a year. We really collected a lot of evidence base and information. Then we moved to a different stage and we told other countries that we should use the principle of universal jurisdiction in order to start investigations and bring into account of some people for war crimes in your territories. But again, we faced a problem there. That was the problem of availability of in absentia trial in the legislation of those countries. And for example, now we are working actively with one of the Baltic states to give to them prisoners of war from the Russian Federation who committed a crime both in relation to citizens of Ukraine and to a citizen of that country. So this is going to be the first precedent within which we will use the universal jurisdiction principle, and the person will be brought to account not based on our domestic legislation, but based on the collection of evidence collected in Ukraine, but within the jurisdiction of that Baltic state. After we worked for a year, we saw that we did not focus enough on the crime of aggression. And then, in coordination with Eurojust, the Office of the General Prosecutor suggested establishing a group inside the group that would focus exclusively on the crime of aggression. Since already then there was a core group, including representatives of other countries, and they were trying to find a mechanism for bringing people to account for the crime of aggression internationally. It was a strange situation because in our national legislation we had this opportunity to bring people to account for international crime, but the international society, the international community didn't have the effective mechanism that would enable them to do this internationally. So we launched this process. And of course, this work has yielded its results. We established the center, and the center was put into operation in 2023. What is the center doing? The center actually includes both investigators and prosecutors from Ukraine and other European countries, and the center works at the evidence collection and at ensuring their effective and reliable storage. That's why the database has been created. It's called CSED, and all the participating countries pass electronic evidence regarding war crimes, regarding the crime of aggression. And we have this backup storage facilities, so in case something happens to the materials of our criminal proceedings because of missile attacks or drone attacks or hacking attacks, we are sure that we will have those electronic copies in reliable storage. After that, we started analyzing the evidence and doing some analytical work by developing some materials. Again, I cannot mention what kind of materials. These are the rules of Eurojust and their confidentiality policy. So actually, we wanted to create a guidebook for the future prosecutors. We will collect the evidence, we do analytical work, we connect all the pieces of this analytical product to the evidence, then we pass it over to the Office of the Prosecutor General, and in the agreement on the ICPA establishment, it is mentioned that ICPA has the mandate to pass the evidence to the Special Tribunal as well, Special Tribunal for the crime of aggression. And the prosecutor, if he is okay with that, can actually use this evidence later on. If not, they will have to collect the evidence themselves, but at least they will know what the basic evidence is and where the information could be obtained from. Thanks a lot. Let me get back to the audience with an open mic, so please feel free to ask questions or to give some comments. First of all, thank you for organizing this discussion. It's really an important discussion with a very important topic. I would say that the establishment of the Special Tribunal is a success story. I would like to express my gratitude to Anton in particular because I know how it all started. So it's a personal success story that this tool has been created. And the most important thing to focus now is how it will really be launched and how it will fit into the overall reality. Taking into account the problems that we have in our country, because the special tribunal will exist in the international arena, and there will be some political, some lawyers' response to the operation of the special tribunal. There is still a lot of work ahead. Again, unfortunately, some problem with the internet in the room. And why can we say that important things have been done? Because architecture is a kind of an agreement between the architect and the materials from which the foundation has been laid down. And it's really true because the whole idea of the special tribunal actually started with the fact that the leadership should be brought to account, and it is subject to the work of international institutions to show that those leaders are violating the architecture of safety and security that used to exist in the world, and they did it via this crime of aggression. So I have two questions. What are the violations that the special tribunal will concern? Because we know that Russia is not playing by the rules, and we cannot always count on the officials in some European countries because Russia has some influence on the processes. And the question is for Anton and Andrei. How could we best employ our system? Well, let me rephrase the question. I think that we should take into account the norms of Ukrainian legislation, but how will the work of special tribunal generally affect the overall course of criminal proceedings in Ukraine? And will there be any transformation of the evidence base to the specific requirements set by the special tribunal? Well, I think that other experts may also like to comment more to answer this question, Anton, but we will start with you. Yes, thank you for your kind words, and thank you for the questions, which are definitely important. As far as your first question is concerned, if I've understood you in the right way, so probably this is the question about the possible stumbling blocks on our way. Well, definitely Russia is not keeping silent. And we have seen some intelligence information regarding what Russia is doing inside international organizations to actually prevent us from launching this initiative. They have a lot of policy papers, a lot of verbal speeches, so they don't like it. And in spite of the fact that they try to show off, and to show that they are not afraid of that, we can easily see that they are afraid of that. And they claim that Russia has given no consent to this. That's why it cannot be somehow applied to Russia. But we don't need the consent of the Russian Federation. It's a crime of aggression against Ukraine, so we don't care. And remember, at the beginning, there was a question asked whether it's only about the Russian Federation or about some other countries, maybe. So we don't need the consent of the Russian Federation, and if they give such arguments, we easily defeat them. But what can they do to really affect the process, I can see two elements here which we need to counteract using political and diplomatic channels, not legal ones already. So the first element is that they may try to make the process as long-lasting and only possible. I'm talking about the enlarged partial agreement conclusion. They may act via some lobbyists, via some of their agents. We know that even in the Council of Europe, there are some countries that are using the narratives of the Russian Federation. So we need to keep talking about that because they will be talking about that in order to delay the process. This is something that I can see as a stumbling block that they may create in our way. Another model they may use, and well, probably we also need to discuss this at the end of our today's discussion, for the sentences of the special tribunal to be finally enforced, there must be agreements with states that will claim that there will be enforcement. So Russia may also try to delay the process of conclusion of such agreements. I think that's the only area where they can interfere. But again, we understand this, and our partners do understand this. That is simple arithmetic. So maybe that will not happen. And my answer to your second question about the enforcement of the whole mechanism. About the operation of the special tribunal. Again, that's something I mentioned. It's done via agreements. We need to have agreements of cooperation with a special tribunal, and now cooperation is probably the most difficult thing in international criminal law. You see what the situation is like. Well, maybe you will go in October to Tajikistan. Tajikistan is a signatory to the Rome Statute. So that's where they may also intervene. But if there is an agreement of cooperation, definitely that will lay down a good and solid foundation. Another question, well, and by the way, the core group also worked on that. Yes, we worked out the draft template cooperation agreement. So how do we make this template cooperation agreement stronger than the types of cooperation that are currently in existence? But we will see how it goes. But anyway, I just wanted to say that we have been working with that. Well, let's probably speak about the enforcement of decisions. So what do you think? Which courts have better chances that their decisions will be enforced? Domestic courts or special tribunals? I think that the answer is obvious. That's why we are trying to prioritize our work towards the establishment of the special tribunal, collection of the evidence, and transferring cases for the consideration to the special tribunal. Anton has mentioned that Russia may give no consent, but this is an international crime, and in the criminal code of the Russian Federation, such actions are criminal. So they realized, these leaders do realize that they are not allowed to act like this. Russia may try to claim that this is individual or collective defense, and there are some other markers that they can make use of, but there is the principle of proportionality, and if Russia tries to explain that it was forced to invade Ukraine to prevent Ukraine's attack against the Russian Federation, and they will claim that the principle of proportionality is there. But we saw what happened in Donetsk. We saw even what happened in Kyiv region. We saw that they are just erasing all the villages and towns. They are just making life impossible in those territories. So the principle of proportionality will definitely not be a good ground and a good argument on their part. There will be the adversarial process, there will be some arguments provided by them, but the main thing is that we already now understand what we need to do now to kind of give the good and reasonable arguments to the prosecutors who will be supporting the prosecution side in those crimes. Yes, Mark and Nadia, I guess you're also willing to comment upon this. Mark?
functioning. It's much more difficult to stop a legal process, a tribunal, than it is to withdraw it if you haven't started it yet. So for me, that's another reason why we need to continue to push for the operation of the tribunal, because once it's established, it will be much more difficult to use that as a negotiation element in the future.
Has mentioned that we need to work through diplomatic and political channels, but it also seems to me that we can work with civil society and we can be doing something special. In particular, we could interact with those critical remarks regarding selective justice, because this is the argument which is really voiced quite a lot today, in particular in the background of the results of the special session on the Kampala amendments, which was conducted, if I'm not mistaken, in July. And quite many countries which supported the establishment of the Special Tribunal did not dare to accept and to adopt the amendments to Kampala to make the crime of aggression a full-fledged crime, the same as all the other crimes mentioned in the Rome Statute. And it seems to me that it is the role of the civil society. It is the civil society that should advocate this stance to the countries which have supported the special tribunal but have not supported this amendment, because this is probably the only safeguard you can be working with, the only preventive mechanism that you can work with in order to unite us and to make Russia deprived of this argument, which they now use, saying that you yourself don't know what you want. Here is a question. Denis Lesanko from the Office of the Prosecutor General. Let me get back to the wider topic of our today's event to the extent it's possible. We have already heard that there will be 20 to 30 top military and political leaders that will be the subject of attention within the work of the Special Tribunal. And taking into account the first ICPA rule, saying that there is confidentiality policy. So I'm interested in the following. Do we have the surnames of the people who will be subject for consideration? I'm not interested in surnames themselves. I'm just interested whether we already have this coordinated list of the people who will be tried by the Special Tribunal. Do we have this coordinated, consistent list, and is everyone on the same standpoint? I'm not interested in specific surnames. Well, of course, we do have this list. I would also add something. It all depends on the finance the Special Tribunal gets. It depends on the quality of the evidence. It also all depends on the professionalism of the prosecutor's side and of the judges of that Special Tribunal. Because if funding is limited and we cannot provide high-level evidence and high-quality evidence, this means that the court proceedings will last forever. But if the evidence is there and the court can really draw a conclusion and the prosecutor can support the prosecution side with good arguments, then it will not that take time to pass those decisions. And if the budget is larger, then the tribunal could embrace a wide range of people and embrace a longer timeline. Suppose not only full-scale invasion, but it could start with the Crimea invasion. But this is actually a rhetoric question. The list is there. It was adopted even before the charter was adopted, because the statute has a provision saying that Ukraine can actually give either the evidence to the Special Tribunal or the investigative proceedings. And by this, we know that now we need to focus on collecting the evidence, high quality evidence from top to bottom, not going from bottom to top, because the lower part of that list could be under the threat of not actually getting to the special tribunal. That's why we prioritize the top of that list. We are collecting evidence on those people, and at first we are collecting the evidence over the period of full-scale invasion. That is the principle of procedural economy, as we call it inside our team, because 90% of the people who have something to do with the full-scale invasion also have something to deal with the occupation of the Crimea and the east of Ukraine before the full-scale invasion. Well, in the diplomatic and legal circles, we also have a clear idea of who these people are. It seems to me this understanding was always there. I don't mean that there was a full list, but the understanding of who is going to be included into that list was always there. And it seems to me that this is another chance for me to comment on what Daria asked at the beginning. Definitely, not only the leadership of the Russian Federation could be the people the special tribunal will work on in the future. The tribunal has ratione materia for the crime of aggression against Ukraine regarding the perpetrator, regardless of who the perpetrators are. This is the basics of the legal logic of any law. We cannot just have a tribunal against Putin or a tribunal for Putin in the context of the crime of aggression. This would be the wrong approach. It's not our work to install such limitations. That's why there could be no tribunal regarding only for the leadership. That is the special tribunal for the crime of aggression against Ukraine, regardless of who the perpetrator is. This is logical, and this is absolutely the correct approach. And I think that now, at least, well, everybody understands that there are at least two states. Well, not three, but two, because the third is still not committing a crime of aggression in the international sense. And actually, this tribunal could also deal with the leaders of those states. This is the Republic of Belarus and the Korean Democratic People's Republic. And there is another state which is on the verge. It has not yet reached the stage where we can speak about aggression. But if we speak about just Russia, so this tribunal could be the one that will at least ensure some accountability. And, you know, the collective West has not managed to do this since the 40s. So I think that these are the interesting things the special tribunal could use in the right way to ensure justice. I have a clarifying question, yes? Okay, please. There is another question. When we are talking about the tribunal, and when we are talking about the judiciary and courts as such, so in the discussion paper and in the speeches, you focused on how the special tribunal would be established, how the office of the prosecutor general of the prosecutor will be established. But there is also another element, the defense. So if we're talking about the special tribunal for the crime of aggression against Ukraine, do we envisage that there will be a trial proceeding where there will be a prosecutor, there will be a defense counsel, there will be legal arguments, there will be emotional, meaningful arguments, and there will be the jury. All those people will be there, and the court will actually legalize the decision that is passed by the society as such. So whether it will be like that, and what will be the individual responsibility of all those people who are on that list? Well, maybe I'm wrong, but I see the process in this format. And here is another question for you. If Russia does not acknowledge the legitimacy of this tribunal and generally denies its mandate, because you mentioned it as one of the stumbling blocks on our way. So how will it be possible to represent the work of the Special Tribunal to the readers and to the listeners in the West? I mean, how do we ensure this right to defense for them not to be able to criticize anything and to see that everything is fair, and for the alien observers who are emotionally not engaged in the process that we are experiencing to really believe that these
Let me respond to the first point, and Anton could take the second. The question on defense is so important. Thank you for saying it. Because so often my experience in international courts is that defense issues become secondary. They're not really the primary concern. But without effective defense and protection of the defendant and representation, then the credibility of the process absolutely disappears. So you have to provide that. When I look at the statute sets forth extensive rights for the accused. I think the statute mirrors those requirements in international law, including effective defense. And of course, I mentioned the requirement for trials in absentia. That is a fundamental safeguard. So I'm comfortable that under the statute that the core group has focused on the defense. But I will tell you one disappointment that I have regarding defense. In the earlier drafts of the statute that I was able to look at, they had an independent office of the defense. So there's the judicial branch, the office of the prosecutor, and the registry. But in the earlier draft, they had the office of the defense. Why did they do that? Because that's the trajectory in international tribunals, is that you create a separate office of the defense. That disappeared in the final draft, and the responsibility for the defense now sits with the registry, similar to, for instance, when the International Tribunal for the former Yugoslavia was created. But since then, it was thought that a separate office of the defense. That's not in the statute. That doesn't mean that I'm critical at all about the safeguards that the statute has set forth for the defense. I'm comfortable with that. But that one part, I would have preferred to have seen the defense unit stay as a separate unit.
Дякую, Марк. Воно насправді, логічно і...
To your comment, it's actually logical, quite logical, and this was... well, I wouldn't be able to say whose stance it was, that it should not be an independent defense unit. Well, I just don't remember this. It was not the stance of Ukraine, but maybe this is connected to some budget and financial things. This was done for money saving. But I think that all the other things regarding the right to defense, in particular in absentia proceedings, because Russia is definitely not going to consider those proceedings legitimate, and the first proceedings definitely will be in absentia. So I think the statute generally contains all those safeguards that we need. You know, we always claim that Russia does not acknowledge legitimacy, but Russia does not acknowledge our legitimacy as a country. We are kind of under Russians. Ukrainians don't exist, but there are some some people with 2 legs and 2 arms and a head, so they don't know even how to call us. So everything that is related to Ukraine will be considered illegitimate by Russia. That's why I'm not that much concerned about Russia considering it illegitimate. Our main goal was to have all those safeguards in the statute. And that will enable us to respond to all arguments from the legal point of view. So I think our constituent documents really produce and provide all those safeguards. Yes, let me also speak because this is a relevant question, not just for international tribunals, but for our domestic trials when we have in absentia proceedings for war criminals of the Russian Federation. We have got, for clear reasons, some lack of positive perception of the defense counsels who are protecting war criminals. But we need to have a defense counsel for the prosecutor not to cross over some procedural boundaries. If in the court proceedings there is no defendant, there should at least be the defense counsel to reproduce his rights. And the defense counsel plays the role of acting in the interest of the defendant and it's securing the rights. So if we have this defense counsel, it's safer for the country because Ukraine has a commitment to ensure compliance with the rights of the defendant. So we need to make this happen. Therefore, it's in all our interests. And I think this refers well both to domestic courts and to the special tribunal, because if there is just some passive defense with no defense actually there, but there is nothing will happen. But if there is good defense, but the prosecutor gives good arguments to fight with that defense, so that will ensure the adversarial nature of the process. Well, thanks a lot.
To understanding the importance of effective defense, and the previous prosecutor here, Andrei Kostin, said the same thing. And we have in the back room the director of the Legal Aid Center too, and I think he would also agree with that. But the fact that everybody understands, from the prosecutor's side to diplomats, the need for effective defense. Why? Because it's required under international law. 2, because if you ensure effective defense, the final decision, the final verdict will be seen as fair and impartial. That's the credibility for Ukraine, both domestically and within the Special Tribunal.
Thank you. It seems to me that we have also had one JustTalk dedicated to defense counsels in war crimes. So I would recommend you to watch this JustTalk discussion because this is really something extremely important in the context of securing fair justice, both domestically and internationally in crimes investigation. So we are actually about to ask our speakers to come with the last reflections for this discussion. I've got one question, and well, probably you would answer this question, but don't limit yourselves to that. Could you please say, from your professional point of view, what do you see as your first steps that need to be taken, that you will take to make the international justice for the crime of aggression against Ukraine really fair and effective tool, in particular the one that will meet the interests of the victims of the crime of aggression? While you're thinking, I could tell that after listening to our speakers, in particular Andrei, I would say that I, as a representative of the Crimea, who also considers herself to be the victim of aggression, would really find it important for the international tribunal and for the national law enforcement system and for all those who will be collecting the evidence for the crime of aggression to do it not starting with a full-scale invasion, but to do it starting with the occupation of Crimea in 2014. That would be important for me, because that is really important to restore justice for all those who are victims of the aggression committed by the Russian Federation against Ukraine. If I may, I will start. We never forget that the aggression was launched in February 2014. And if I speak about prioritizing something, we do it just because there is a need to do it like this. We have the, so to say, internal consumers and external consumers. And internal consumers, which are our courts and our citizens, definitely have this right to justice restoration. They have the right to be heard. And this will definitely be happening in Ukrainian courts if that does not happen at the international court. And with this in view, we have this statement that the Special Tribunal had just decided to work with full-scale invasion period. But this doesn't mean that we are not collecting the evidence and are not sending the evidence about the prior period to our domestic courts in the meantime. What we would do, well, my vision is very simple regarding how we could make our plans come true. We do understand that we are a tool. We are ready to be a tool. We are ready to be collecting the evidence, to analyze the evidence, to prepare the evidence, to submit, to comment the evidence, to translate the evidence, to do whatever is necessary to secure the work of the international judicial institution. We already have some experience of doing that, of working with that sort of information, of using that information, of working with our partners, following the universal jurisdiction principle in other jurisdictions. We are ready to listen to the recommendations, to get the assignments, and to perform those assignments to really secure a sufficient collection of the evidence that would be required for considering those crimes.
We are acknowledging, celebrating the 80th anniversary of the creation of the UN Charter. That charter is the constitutional framework of the international community. And when it was ratified, it focused primarily on peace and security. And Article 2 of that charter prohibits the threat or use of threat against the territorial independence, political independence of another country. That is exactly what Russia has done starting in 2014 and today. This war and the international community's response is not just for Ukraine. It's not just for justice for Ukraine. It is critical to uphold those principles that were created 80 years ago. That is what created the world order that we live in today. That is what is being threatened. And that is why this tribunal must work and must function.
Да, дякую, Дар'я. Ну, да, якщо можна рефлексію, то я би дав, можливо, на
For
певні
your
питання, які...
question, I will try to reflect upon this. And you know, there are a lot of issues that still need to be mentioned because we all need to think over them. Let's say the issue that you mentioned about selective justice. We heard it from Daria, we heard it from Nadia, and I'm sure that a lot of people are thinking about selective justice. But before this session on Kampala 2, the ministry got a lot of organizations know this. And we reported to our leadership that Ukraine has to support Kampala 2, and we actually did support through official speeches. Kampala 2, we had the initial speech, then the speech at the end. So And we already have partnerships between civil society organizations, the government, experts, and I think that this is something we need to really cherish. We need to be cherishing this trust to each other. I think that we all need to understand that certain things need to be done and these things will be done. We understood that Kampala 2 will not be a success now in July. That was obvious because they were not ready for that. But again, we also understood that this needs to be supported because we are a state which must have a consistent moral and political stance. Therefore, it's really important to understand this. We never had any statements made about that in social media because it's not all about that. But it's important that Ukraine was there. It officially supported the Kampala 2 idea, and we really had a lot of good words supporting us and supporting the idea of bringing people to account for the crime of aggression. So we understand how important it is to somehow deal with the stereotype of selective justice. It's difficult to do, but we need to understand that the special tribunal is an ad hoc tool here and for us. The crime of aggression will unfortunately stay in the international criminal law, and the special tribunal will probably not give the answer to all the questions. But as Mark says, as all those present here have said it, and Mark said, if this tribunal will fail, then there will be no effective fight against the crime of aggression ever. Because if this war does not get an effective response, nothing will happen. It's a pleasure that Mark from IBA is with us. We have a lot of other experts from expert organizations, civil society organizations, that supported us on the way to establishment of this tribunal. And I think that it's great that we have done this, but we need to keep going, and there is still a lot of work to be done. The issue of immunity Mark mentioned, well, I think that a lot of colleagues have been thinking about this immunity. It's really a difficult, a tricky issue. The countries signatories to the Rome statute are now discussing whether the ICC has any jurisdiction regarding the countries that are not members to the Rome statute. Well, I don't mean that there will be a revision of this issue, but there are some comments regarding the countries that are not signatories to the Rome statute. The ICC is supposed not to be able to do anything about that, which is dangerous, in particular in the context of investigations we will have in Ukraine. But let's see what comes next. Let's see what comes next week. Let's see whether there are some institutional sanctions and not only personal sanctions regarding the ICC. Well, then we will have Tajikistan, we will have Mongolia, the second Mongolia, so to say. So there is no ideal answer. We would really like to get, as Mark said, this cutting stone, this ideal answer, but that's life. And you have to choose. Either you have something what is effective, credible, legitimate, or you will have nothing. Well, regarding victims, I fully agree with Nadia. That's quite an issue. I don't want to actually say anything regarding the people who worked with that ICC statute, but even many professional lawyers said that, come on, the crime of aggression is so much special. What kind of victims are you going to have? The whole people, the whole nation is a victim. So when we were developing the statute for the special tribunal, that's what people told us. So I think that if we have what we have in Article 21, and if the Special Tribunal will keep working on that, yes, it will be necessary to further communicate it at the level of the rules of procedure, and it's going to be of interest. Regarding in absentia and eternal life of the special tribunal, no, that will not be an internal tribunal. That is an ad hoc one. But we have a residual mechanism in the statute which shows that within Europe there will still be this backbone. And in case a person who is a perpetrator and there is already an indictment regarding this person comes for a retrial, we will have this residual mechanism to be able to do this. So this residual mechanism of backbone will stay for long. Well, as far as agreements of cooperation is concerned, let me stress once again that cooperation is the most important thing, because without cooperation, nothing will work, nothing will happen. And the last question is the question asked by Daria. How do we make justice for the crime of aggression effective and just? I think that generally the international criminal law is not yet ready to make the crime of aggression equal with other crimes, international crimes. We will see what happens to Kampala 2 in 2029, but I think that we understand what the specific attitude of some states to this crime is. But for us, it's really important to ensure fair justice for the crime of aggression, because it's our responsibility. If we really do everything in our place, this will mean a job well done. And after, it's our responsibility regarding Ukraine. But if we can save the world after that, it will be just another success story. But now we have to focus all our eyes on our issue by still supporting Kampala 2 and by still supporting this initiative. Thank you. So let me go on with what the previous speakers said. It seems to me that this tool has been created as an additional opportunity for securing justice for the justice for as regards to the crimes that the population of Ukraine experienced over this period of time. But it seems to me that if we have a look at the international arena, at the ICC in general, we can see that the establishment of the Special Tribunal is something we have to invest a lot into. We have to invest a lot of resources and effort now not to have another opportunity lost. That is something that we can at least try and do all together. For the sake of all of us, those who think that they are also victims of this crime of aggression against Ukraine, this is a real challenge from many points of view. But this readiness to work, as it seems to me, should be well developed with each of us, and we need to understand what each of us can do to make it happen. But I also think that there are a number of actions that we could already take to start legitimizing this tool in the eyes of the victims. And well, here I could refer to the state. There should be amendments made to legislation. Then the Office of the Prosecutor General should get the mandate to cooperate with the Special Tribunal. Well, lawyers will probably give me a helping hand, but in our organization, we are discussing whether we should also amend the constitution or not. Then the procedure of case transfer should also be envisaged in the Code of Criminal Procedure. So these are the actions that we need to be taken. They all depend on us, and the speed of the process also depends on us. And then comes the consistent and well-coordinated work and the steps mentioned by Anton. And I think that finally the international advocacy will also play an important role in the acceleration of this process. And that is an assignment for the civil society, not just of Ukraine, but of different countries. Thank you. Thank you, dear speakers, for this really difficult discussion. Thanks a lot to all of you personally for your daily effort, for our today's discussion. Thank you for making justice happening for all the victims, for accelerating this process. We really need to get the assistance from international partners because then we may fight this problem, and then probably our partners will never need our experience, because we will in this way prevent this crime in the future. And let me heartily invite you for some coffee where we will continue networking. Thanks a lot.